new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2TVGH for amazing content right from your mobile phone or computer. Net2TV, beyond the limit. Log on to www.net2tvgh.com for your local news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2TVGH for amazing content right from your mobile phone or computer. Net2TV, beyond the limit.
The economy, politics, sanitation, agriculture, education,
petitioner's petition before this court is a challenge to the declaration. And it's not just a challenge about figures, but it's a challenge related to the constitutional consequence arising from these figures. And we are saying that we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you're supposed to be speaking to paragraph 30, which is about the original collation. And the question from my brother on my right was that there is nothing in your pleadings about the collation process.
But, my lords, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. So the witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through these 4 stages, and so she is in effect explaining herself in terms of her conduct. And we are saying that on that basis, the witness is entitled, because for us, if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead in and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? Now, this is perfectly legitimate if I were leading in the normal process.
Counsel, in fact, with with the greatest respect. My problem is, yes, in the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127, the law that regulated election.
And the petitioner does not seek to raise an issue about the
paragraph 30 of the witness statement. The witness is trying to raise issue with CI 127.
No, my lord, the petitioner is raising an issue over the fact that the first respondent, without good reason, interposed that legal collision sentence.
You see, what were the provisions in CI 120? That was the regulations that regulated or governed the elections in the conduct of the elections. And if you did not raise any issue with it, that the first respondent did violate CI 127, and in your evidence you try to raise issue with how, for the first time, how there have been changes in now strong room to consensus coalition. That is what CI 127 said the election should be conducted. So, and you never raise any issue with it. Then in your evidence you try to raise issue indirectly.
My lords, with the greatest respect, I believe that we are confusing an issue about whether we are seeking to challenge or there is an issue with CI 127. And we are saying that that is not the objective. But CI 127 has to be executed. In making this interposition without good reason, if the petitioner has, as a result, had problems in the collation which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outlined in their answer. My lords, I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from paragraph 4.
Mr. Chikita, we don't want you.
Yes, so
that one. We are familiar with that.
So my lords, if I could, in oral testimony, legal him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent? He says they went in accordance with this and this and this and that. Well, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of votes and so on. There are pleadings made in relation to that with exhibits provided. And my lords, I do want to insist, and your lordships can correct me, if you were being led in the witness box in oral evidence, would I not be able to put the case of the first respondent to him?
I could, but the way you have framed the evidence in paragraph 30, whom are you blaming? Mr. Chikata, look at paragraph 30 carefully. Whom are you blaming?
Whom am I blaming?
Yes, this evidence.
Blaming?
Yeah, blame. B-L-A-M-E. That blame.
My lord,
is it Parliament or the first respondent or the structure that was
my lord, Parliament has nothing to do with this.
Yeah. Because what he did,
Parliament has nothing to do with it, because this is subsidiary legislation.
It was laid before Parliament.
Yes, but I mean,
It was laid before Parliament for 21 days.
My lords, I believe that is really not the essence of Because it
totally is. It's the essence.
So is Parliament responsible for all subsidiary legislation?
It is money. As far as I understand it, you are blaming CR 127 on her, because you are saying that out of 127, CR 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
No, we are saying that the implementation of the law is what occasioned the problems, and that this interposition without good reason was the opportunity for that really error-ridden implementation to take place. That is what we're saying.
But the problem is with the implementation of the law. Then in essence, the first defendant, the first respondent, did violate the law. But you've not indicated anywhere.
You don't have to violate a law in order to implement it in a way that if
you don't implement it correctly, as provided in the law, then you have violated it.
Well, my lords, we are saying that there was a lack of due process. There was a lack of due process in the implementation. The lack of due process. The lack of due process is certainly an aspect of the implementation of the law. It does not require us to challenge the law or to say that the law itself is the problem. We're saying that in the implementation of the law, the statute, a piece of subsidiary legislation that she introduced without good reason, we're saying that that was a part of the problem. And we've given a sample of why that occasioned the problem. In paragraph 32, indeed, aggregating the votes, aggregating the total valid votes as shown by the 275 submission released by the first respondent on this website, the resultant figure is actually 13,012, which is different from the 9. How can there be an objection to that passage of evidence? That is a passage of evidence in which reference is being made to the website of the first respondent in order to address figures that she has sought, or figures that her first respondent has put forward as a petitioner's petition before this court is a challenge to the declaration. And it's not just a challenge about figures, but it's a challenge related to the constitutional consequence arising from these figures. And we are saying that we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you're supposed to be speaking to paragraph 30, which is about the collation. And the question from my brother on my right was that there is nothing in your pleadings about the collation process.
But, my lords, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. So the witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through, these 4 stages, and so she is in effect explaining herself in terms of her conduct, and we are saying that on that basis the witness is entitled, because if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead in and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? Now, this is perfectly legitimate if I were leading in the normal process.
Counsel, in fact, with the greatest respect, my problem is, in the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127. The law that regulated election.
And the petitioner does not seek to raise an issue about the lawfulness
paragraph 30 of the witness statement. The witness is trying to raise issue with CI 127.
No, my lord, the petitioner is raising an issue over the fact that the first respondent, without good reason, interposed that legal collision sentence.
You see, what were the provisions in CI 120? That was the regulations that regulated or governed the elections in the conduct of the elections. And if you did not raise any issue with it, that the first respondent did violate CI 127, and in your evidence you try to raise issue with how, for the first time, how there have been changes in now strong room to constituency coalition. That is what CI 127 said the election should be conducted. So, and you never raise any issue with it. Then in your evidence you try to raise issue indirectly.
My lords, with the greatest respect, I believe that we are confusing an issue about whether we are seeking to challenge or raise an issue with CI 127. And we are saying that that is not the objective. But CI 127 has to be executed. In making this interposition without good reason, if the petitioner has, as a result, had problems in the collation which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outlined in their answer. I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from the Mr. Chiquita, we don't want you. Yes, so that one, we are familiar with that. So my lords, if I could, in oral testimony, leaving him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent? It says they went in accordance with this and this and this and that. Well, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of votes and so on. There are pleadings made in relation to that with exhibits provided. And my lords, I do want to insist and your lordships can correct me, if you were being led in the witness box, would I not be able to put the case of the first responder to him?
I could, but the way you have framed the evidence in paragraph 30, whom are you blaming? Mr. Jikata, look at paragraph 30 carefully. Whom are you blaming?
Whom am I blaming?
Yes, this evidence.
Blaming?
Yeah, blame. B-L-A-M-E.
That blame. My Lord,
is it Parliament or the first respondent or the structure that was
my Lord, Parliament has nothing to do with this.
Yeah. Because what he did,
Parliament has nothing to do with it, because this is subsidiary legislation.
It was made before Parliament.
Yes, but I mean, my Lord,
it was made before Parliament for 20 days.
My Lord, I believe that is really not the essence of, because it really is. It's the essence. So is Parliament responsible for all subsidiary legislation?
No, that's money. As far as I understand it, you are blaming CI 127 on her, because you are saying that out of 127, CI 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
We are saying that the implementation of the law is what occasioned the problems, and that this interposition without good reason was the opportunity for that really error-ridden implementation to take place. That is what we're saying.
But the problem is with the implementation of the law. Then in essence, the first defendant, the first respondent, did violate the law. But you've not indicated anywhere.
You don't have to violate a law in order to implement it in a way that if
you don't implement it correctly, as provided in the law, then you have violated it.
Well, my lords, we are saying that there was a lack of due process. There was a lack of due process in the implementation. The lack of due process. The lack of due process is certainly an aspect of the implementation of the law. It does not require us to challenge the law or to say that the law itself is the problem. We're saying that in the implementation of the law, the statute, a piece of subsidiary legislation, that simple way of trying to interpret Rule 69C4 would lead to gross absurdity if we were to follow it.
All right.
Introduced without good reason, we are saying that was a part of the problem, and we've given a sample of why that occasioned the problem. In paragraph 32, indeed, aggregating the votes, aggregating the total valid votes as shown by the 275 submission released by the first respondent on this website, the resultant figure is actually 13,012, which is different from the 9. How can there be an objection to that passage of evidence? That is a passage of evidence in which reference is being made to the website of the first respondent in order to address figures that she has sought, or figures that her first respondent has put forward
as far as I understand it, you are blaming CI 127 on her, because you are saying that out of 127, CI 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
No, we are saying that the implementation of the law is what occasioned the problems, and that this interposition without good reason was the opportunity for that really error-ridden implementation to take place.
That has not challenged the validity of the election. It has simply picked on some errors in the announcements and the tabulation of the results. It has not. In these two paragraphs, 32 and 33, the witness is also not saying anything about the validity of the election. Yes. So why not keep quiet over it? That's what I've been telling my students in advocacy lectures. Yes, we will not keep quiet over it because it could be prejudicial. It may cast an unnecessary cloud over the elections. It is not been pleaded, and I believe that they cannot leave evidence that is contrary to their pleadings. Thank you.
But I want to know whether Mr. Milivo has something to say about the witness statement. Yes, Justin.
Yes, my Lord. My Lord, I have nothing more to add to what Mr. Akotuampo has said. Thank you. I associate myself with his submissions.
Of Mr. Johnson Shedwin Ketia, who has been sworn in as PW1. The objections to those paragraphs, precisely paragraphs 21, 6, 7, 25, 26, 28, 30 and 32, 33, and 37. Both counsel based their objections to the paragraphs in the witness statement of PW1 on two grounds. A, that some of the paragraphs under attack are not based on the pleadings on record. B, some of the statements are unduly scandalous and prejudicial. It would be preferable to set out the paragraphs in the witness statement which in our view are amenable to be struck out from the witness statement. We are of the opinion that paragraphs 6 and 7 ought to be struck out as the witness, Mr. Johnson Shedwin Ketia, cannot testify on the facts in the said paragraph. It would have been admissible if the petitioner is himself testifying. The statements in the said paragraphs are not within the knowledge of the witness. We find paragraph 21 as a matter which has its foundation in the pleadings and same is accordingly maintained. As regards paragraph 25, we found that that is the sentence beginning with, quote, in fact, the ever-changing figures, end of quote, to the end of that paragraph is hereby struck out as not based on the pleadings. In respect of paragraph 26, the court is of the opinion that the statement from line 5 above, beginning with, quote, the chairperson of the first respondent, end of quote, to the end of the paragraph is struck out on the basis that it has no foundation in the pleadings. As regards paragraph 28, from line 6, that is the sentence beginning from, quote, the secrecy and the lack of transparency to the end, end of quote, to the end is not borne out of the pleadings, and we accordingly struck it out. In respect of paragraph 30, the court is of the view that it has no foundation in the pleadings, as it just refers to CI 127, which the witness cannot testify on the statute. As regards paragraph 32 and 33, we found that they are based on the pleadings and therefore ought to be part of the witness statement, and they are accordingly maintained. In respect of paragraph 37 of the witness statement, we found that it is just an inference to be drawn and not evidence. We therefore proceed to strike it out. The court therefore orders the paragraphs referred to as offending the law are hereby expunged from the witness statement of PW1.
My lords, we are most grateful. We are most grateful to the court.
As the court pleases, and just for the sake of clarity, I would like to understand what was said in respect of paragraph 30. Paragraph 30, because the reference to the regulations in CI 127.
127.
That's in the first sentence, but the rest of the paragraph, including the Exhibit C, is not related.
Yeah, the whole of paragraph 30.
The whole is in
it's
the whole of paragraph.
Yes, sir.
That's the whole of paragraph 30.
Then you must look where those are
Now, the 2020 December 7 elections was conducted under rules passed by Parliament. Is that correct? The 2020 December 7 elections were passed, was conducted by rules passed by Parliament. Is that correct?
That's correct, my lord. It is supposed to be passed, to be conducted by the rules, but we have issues about the application of the rules in the conduct of the elections.
CI 127 is binding on the petition. That's well, yes, it was expunged, sorry. The petitioner appointed agents for each of the polling stations in the country. Is that correct?
That's correct, my lord.
How many agents did the petitioner appoint for each polling station?
2 agents.
Now, at each polling station, the petitioner and indeed all the other candidates had agents. Is that correct?
I cannot speak for all other candidates.
Now, you trained your agents on what their duties at the polling stations would be.
Yes, my lord, that's correct.
You trained your agents on how Forms 8A and 8B was to be completed in each of the polling stations.
That's correct, my lord.
You trained your agents on how each form was self-auditing and designed to reduce errors and mistakes. Is that correct?
That's correct, my lord.
You also trained them that at any point that they had a problem with what was happening at the polling station, they could refuse to sign the form but state the reasons for it. Is that correct?
That's correct, my lord.
You also trained them that if they stated the reasons for not signing, the issue will be taken up at the constituency coaching centers. Is that correct?
That's correct, my lord.
You also trained your agents that at the end of counting and entering of figures, they collect their copies of the Form 8, whether or not they signed it. Is that correct?
That's correct, my lord.
You also appointed agents for each of the 275 constituency coalition centers. Is that correct?
That's correct, my lord.
You trained them that unresolved issues from polling stations will be noted on Form 8B for resolution at the constituency coalition centers. Is that correct?
That's correct, my lord.
You also trained them to expect to receive the duplicates of the Form 8Bs that have been given to them at the polling stations. Is that correct?
That's correct, my lord.
Now, you also train them to cross-check their Form 8Bs with anything that is done at the constituency coalition center. Is that correct?
That's correct, my lord.
You also train them that from all the information on Form 8B, the EC officials will collate the results onto Form 9. Is that correct?
That's correct, my lord.
You train them that after collating on Form 9, the results will be entered on Form 10. Is that correct?
That's correct, my lord. But all with the involvement of our agents.
Now, you also train them that if they had any issues with Form 10, they could refuse to sign it and state the reasons therefore. Is that correct?
That's correct.
Now, you also train them that once the Form 10s were completed, they were entitled to their copies.
That's correct, my lord.
So it is right to assume that your agents had all the Form 10s with them. Is that correct?
Come again, my lord.
I'm saying that it is right to assume that based on your answers, your agents had the Form 10s with them.
Yes, my lord, it could be assumed.
Yes.
Now, whether that is the case is another matter.
Now, you also agree with me that with our elections, results are declared at all the polling stations before they move on to the constituency. Once the results are counted, they are declared at the polling station before we move on to the constituency centers.
Yes, my lord, unless there is a challenge about a particular polling station results.
Yes. And at the constituency level, the collated results are put together and then a winner of a particular constituency is declared. Is that correct?
We have two elections at the constituency that are collated at the constituency level. I don't know which one. Is that the presidential or parliamentary?
Sir, you are here because of the presidential election. Is that correct?
Okay, yeah.
My question is in reference to the presidential election.
The declaration is not done at the constituency level. They indicate the tally for each candidate. The presidential election results are declared at the national level by the returning officer.
Are you therefore saying that at the constituency level, your agents do not know who has this number of valid votes at the constituency level?
That's what I'm calling the tally. The tally of the votes are known. But that is not the declaration of the presidential election.
Okay, good. You trained your agents that the Form 10s will be transmitted to the regional coalition centers. Is that correct?
That's correct, my lord.
Now you also appointed agents to each regional coalition center. Is that correct?
That's correct, my lord.
Indeed, some of your agents, as announced publicly, were lawyers. Is that correct?
That's correct, my lord.
Now, you also trained your agents that all the information on Form 10s will be collated onto Form 11. Is that correct?
That's correct, my lord.
You also train them that from collating the results on Form 11, the results will be entered on Form 12. Is that correct?
That's correct, my lord.
Now, you also train them that at that point, they would be invited to either sign onto the Form 12 or object. Is that correct?
That's correct, but they are involved, so they are not sitting somewhere only to be invited to sign. They are involved in the collation, and if they agree that the process has been proper, they are invited to sign.
Okay. Now, are you aware that of the 16 regional collation forms, your agent signed 13 of them?
Yes, my lord.
Are you also aware that one of such forms that was signed was in reference to the Ashanti region? Is that correct? One of the forms that your agent signed, it was in reference to the Ashanti region?
Yes, my lord.
Your agent signed the form for Ahafu. Is that correct?
That's correct, my lord.
Your agent signed the form for Oti. Is that correct?
That's correct, my lord.
Your agent signed the form for Northeast. Is that correct?
That's correct, my lord.
Your agent signed the form for Bono. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper West. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper East. Is that correct?
That's correct, my lord.
Your agent signed the form for Central Region. Is that correct?
That's correct, my lord.
Your agent signed the form for Western. Is that correct?
That's correct, my lord.
Your agent signed the form for Savannah. Is that correct?
That's correct, my lord.
Your agent signed the form for Volta. Is that correct?
That's correct, my lord.
And your agent signed the form for Bono East. Is that correct? Bono East.
Bono East.
It was signed by Ali Muhammad Samsudin.
That's correct, my lord.
Good. Now, on each of those forms, your agent signed to declare as follows. Quote, we the undersigned do hereby declare that the results shown above are true and accurate account of the ballots in the region. Is that correct?
That's correct.
Now, at the National Collation Center, which is the headquarters of the first respondent, you appointed 2 persons to that place for the collation. Is that correct?
That's correct, my lord.
One of such persons is Rojo Metonunu. Is that correct?
Yes, my lord.
And Mr. Rojo Metonunu has been a former deputy minister before.
That's correct.
And Mr. Rojo Metonunu has been involved in elections and has even litigated 2 cases in these courts. Is that correct?
My lord, I can't testify to the fact about his litigations, but I know he has been involved in our elections.
Now, there's a reported case. Okay, right. Right. Now, are you aware that at the National Collation Center, Mr. Rojo Metonunu certified 12 of the 13 forms signed by your representatives?
My lord, I cannot testify or deny, but the other agent who will be present in court to testify as to what happened in the National Collation Center, my lord.
Right. Now, let us go to your witness statement. You spoke about Exhibit D, the letter from the National Democratic Congress.
Yes, my lord.
Dated 9 December 24. I suggest to you that that letter was not delivered to the first respondent.
My lord, our agent who was in the headquarters of the first respondent will be present in court and will attest to that fact.
So you do not know whether it was submitted or not?
A report was made back to me that it was submitted.
I am putting it to you that that letter was not submitted to the first respondent. Yes. I am putting it to you that that letter was not submitted to the first respondent.
My lord, that fact will be confirmed or denied by the agent who will be in the box subsequently.
So you are telling this court that you do not have personal knowledge of whether or not the letter was submitted to the first respondent?
My lord, I indicated that I had a report, a feedback that it had been submitted, and since I wasn't present there, I cannot say it as a matter of something that has come to my knowledge.
Right. Now, let's go to your letter. Your letter is in two parts. Is that correct? You can look at it.
You have it.
It is marked Exhibit D.
Yeah.
Would you be kind enough to tell the court the person who signed this letter?
My lord, it was signed by my deputy on my behalf.
What's the name of the person?
Peter Boama Otokuno.
Right. Now you agree with me that the portion marked C talks about parliamentary elections and therefore has nothing to do with the petition in this court.
Yes, my lord.
You also agree with me that despite all that you've written about Ashanti, Ashanti was signed by a gentleman called Broja Jemfi. Do you know him?
Yes, my lord.
And I'm certified by Mr. Rodo Metonunu.
My lord, the agents who will come subsequently will be able to confirm that or deny it. Please, I would like to take the question again.
I'm asking you whether you know that when Ashanti came in, duly signed, Mr. Rodo Metonunu signed against it. You know or you don't know?
My lord, the documents that come to our notice is
the strong room, as you call it. Mr. Rodo Metonunu signed it.
Well, I can't testify or deny because what happens in the strong room is within the knowledge of people who are in the strong room.
Now, you attach to your letter 2 sheets
from the eastern region. Is that correct?
That's correct, my lord.
On the first sheet, your agent signed the form. Is that correct?
Yes, I've looked at. Yes, my lord, that is precisely what I'm about to do. I have done the collations, the additions, and I've realized that the totals on both sheets are the same figures, but the figures that add up to the totals are different. And the one marked in blue is actually accurate.
No, we'll come to the one marked in blue. I am saying that if you add up all the valid votes assigned,
the numbers there, but I don't remember the actual figure that I got. If the court will permit me, we can add and find out what it is. Yeah. But all our phones have been taken.
My lord, my lord, we brought the calculator.
Yes.
If the court will permit, you can do that.
Yes.
Order in court, please. Order.
1, 4, 6. So this is appears your calculator is not 1, 2, 9.
Is order in court.
Lord, I have 1,196,751. Correct.
Now, kindly deduct that figure from the figure written on the form. That is 1,236,940. What will you arrive at?
One, 40,109.
40,000.
109.
189.
189. Sorry.
It is 189.
Yeah.
Good. Now, look at the last page of your Exhibit E, which is the sheet that you attached to your evidence. Listening. Now, there is a constituency there called Ayenswano. Ayenswano. Do you see 40,189 over there?
Yes, my lord.
I am suggesting to you that the second sheet that your agent did not sign was corrected to include the Ayenswano constituency results.
Well, I cannot testify to that because if there is any correction to be made on any declaration, those who are part of the declaration must be present for the corrections to be made.
Yes, but you also are aware that where the person whom you have appointed to represent you leaves and refuses to be part of the process, those who are there sign onto the form and the process continues. You are aware?
Yes, I'm aware, but
now I am putting it to you that when the Ayenswano results were added, all the candidates got the additional votes that they got in Ayenswano, thus making extra gains to make the total valid votes 1, 2, 3, 6, 9, 40. I am putting it to you.
My lord, can you come again?
I am putting it to you that when Ayenswano results that I have just shown you, that if you take the difference that you got from the first sheet from what they had written, you get 4189, and that 4189 on your own spreadsheet Exhibit E, it is spread across all the candidates. The only person who didn't get a gain was Hassan Ayarika. I'm saying that if you put it together, the gains that each candidate made in Ayenswano, the total will now come to 1, 2, 3, 6, 9, 40. And I'm putting that to you.
Yes, my lord.
Good. Now, therefore, I am further putting it to you that the Eastern region sheet had no problem for which you ought to have written to the first respondent.
I deny that, my lord.
Now, I am further putting it to you that the 3 remaining constituencies that your agents, the 3 remaining regions that your agents did not sign, the petitioner won those regions.
My lord, if the figures are in contention, we are not able to determine who won.
Now, those regions are Western North, Northern, and Greater Accra. I'm putting it to you that the candidate won at those regions when the coalition was done. That's the petitioner.
My lord, I repeat that if the figures are in contention, it is difficult to determine who won.
Now, are you therefore saying that with respect to Greater Accra, you do not know that the petitioner won the election?
My Lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention.
You see, I am putting it to you.
And in the presidential elections, regions are not won.
Yes, my Lord. Well, my Lord. Well, my Lord.
In the presidential elections, regions are not won. There is one presidential elections and one returning officer who declares the winner at the national level. No other declaration of the presidential elections take place anywhere else.
Right. That for the record, Western North was won by the petitioner, and the Western North form, although not signed by your representative, it was certified by Mr. Rojo Metonunu in the strong room.
My Lord, the agents in the strong room will mount the witness box and they will be able to testify whether they signed or did not sign.
Do you still stand by your petition in this court? The petition that you filed, do you still stand by all the averments in it?
Yes, my Lord.
Now, let's look at paragraph 12 of your petition. Sorry, the petition of the petitioner, sorry. Paragraph 12 of the petition of the petitioner. Kindly read paragraph 12 to the court.
Paragraph 12. Yeah, I'm ready.
Paragraph 12 of amended petition, sorry, my lords. Have you seen it?
Yes, my Lord.
Kindly read it to the court.
If the total number of valid votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 13,121, 30,121,101. A figure that is completely missing from the purported declaration. 111. A figure that is completely missing from the purported declaration by Mrs. Jean Adukwe Mensah on 9th December 2020 and the purported ratification on 10th December 2020.
Now, I am putting it to you that the figure in the paragraph 12 of the petitioner's petition shows clearly that the number mentioned by the first respondent as the valid votes, total valid votes, was an error, which you have admitted in your petition.
Can I hear the question again, please?
I am putting it to you that as at the time you filed this petition, you knew that the figure 13,121,111 was the correct total valid votes that ought to have been announced on the 9th. as you have said in your petition. I'm putting it to you.
My Lord, these are figures we computed from the first respondent's own data that was supplied. These are not our figures.
Well, you are bound by your petition, so let's go on. At the point that the declaration was going to be done, you have stated that your agents, Mr. Metununu and Dr. Pesa White, left the strong room. Is that correct?
That's correct, my Lord.
I am putting it to you that they left the strong room because they realized that the petitioner had lost the election.
My Lord, I can't attest or deny that one, and these are matters in the personal knowledge of the agents who will be mounting the witness box subsequently.
And they left the strong room because they didn't want to sign the Form 13.
I can't attest to that.
And I'm putting it to you that the total valid votes as at the 9th of December 2020 and captured on Form 13 is just the same as the total valid votes in the form in paragraph 12 of the petition.
My Lord, we don't know which is the total valid votes as we stand here, because the first respondent has turned out several different figures. So our case is that Ghana does not know the results of the presidential elections as we sit here now, because the petitioner who has the constitutional duty to conduct the elections has not, the first respondent who has the constitutional duty to conduct the elections and report an exact figures has failed in that duty. So we are confronted with several figures, and it depends on what you want to believe.
Are you saying that you do not believe in the figure that you wrote in your petition?
My Lord, I stated that we picked these figures from the respondents' own calculations, not ours. We haven't supplied.
And I am putting it to you that if your representatives had not left the strong room, they would have seen that those figures, 13, 121, 111, was the total valid votes as captured on Form 13.
My Lord, I can't respond on behalf of the agents. I have indicated that one of them will be in the witness box to testify.
I am further putting it to you that 8 out of the 12 presidential candidates stayed back and signed on the Form 13.
My Lord, I have indicated that the processes within that National Coalition Center are not within my personal knowledge, and so I cannot answer, I cannot admit or deny.
Now, at the time the petitioner filed this petition, he knew the results from the Techiman South constituency, not so?
My Lord, I'm not the petitioner.
Okay, we'll leave it. We'll address it.
Now, let me refer you to your form, your Exhibit E. Look under Bunu East. Bunu East.
Yeah.
Do you see the valid votes that the petitioner obtained?
As per the computation of the first respondent, yes. Because these are not our figures, they are figures from the first respondent.
Right. You also agree with me that the petitioner never obtained all the 128,000 registered voters' votes from the Techiman South constituency as you purport to show in your evidence. I'm putting it to you.
There's nowhere in the evidence that you purport to say that the petitioner got all. Respectfully, there's nowhere in the evidence where the witness says that the petitioner got all the registered votes in Techiman. There's nowhere in the evidence to that effect. And I think this is just to kind of mislead the witness.
Yes, my lords. My lords, I am not, with the greatest respect, misleading the witness. Lords, as at the date that the witness filed his witness statement on he signed his witness statement on the 27th of January 2021, he, in paragraph 12, sought to make analogies with the Techiman South total number of registered voters. And that is why I am asking him genuine questions based on his own documents that he has brought before the court.
My objection is very simple. He's made a specific statement that the petitioner, the petition says that all votes in Techiman South were won by the petitioner. There's no way. This talk about by analogy and so on. Let him point to where in the witness statement.
Mr. Amenubo, please.
Yes.
Reframe the question.
Now, yes, my lords.
He's raised an objection. What is your response to that? You are reframing the question.
Lords, I'll rephrase the question.
Okay.
Right.
And then tell me that.
Now, as at the time you filed this petition, I am suggesting, as at the time you filed your witness statement, I'm suggesting to you that you could not include paragraph 12 because the total valid votes that the petitioner had obtained were known. I'm putting it to you. In the Techiman South constituency, they were known.
As at the time
you were
filing the witness statement?
Yes.
Yes.
They were known?
Yes.
Good. I'm further putting it to you, therefore, that as at the time that the petitioner filed the petition, all the total valid votes in Techiman South were known.
On behalf of the petitioner.
So I am putting it to you.
Yes.
That using all the total valid votes in the Techiman South constituency, that's registered voters in the Techiman South constituency, to do your analysis is incorrect. I am putting that to you.
My Lord, the analysis was based on what the first respondent herself claimed. So all the information there, all the figures that were stated there were from the first respondent's own account when they were declaring the results. And if I may proceed, the first respondent claimed that even though they have not had the results of the Chimain South, they feel secure to proceed because even if all the votes of the Chimain South were to be added to the petitioner's tally, it will not change the outcome. Yes. So the analysis we did there was to show that based on the figures she herself declared, that statement could not be correct.
I am putting it to you that the first respondent's chairperson was right, because as at the time she was making the declaration, you knew that the total valid votes in the elections was 13,121,111. I'm putting it to you.
My Lord, I don't understand the question. That I knew, or the chairperson who was doing the declaration knew? Because I didn't do declarations.
You, as the witness in this box, you knew about that. I'm putting it to you.
That when the first respondent was making the declaration on the 9th, that I knew that the total figures, total of the votes was 13,121,111.
Yes, because you stated so, the petitioner stated so in his petition, that that ought to be the correct number, and the first respondent in her answer agreed with you. So I'm putting it to you that you knew.
My Lord, you see,
the question.
I don't understand why you seem to be confusing me with the petitioner. because I don't understand.
You see, that's why we have to strike out some of the evidence, because you can't speak to them. And so that's the basis upon which we have to strike out some of the evidence. And we are confirming our position.
Oh.
What is the answer? Well, I'm still waiting for the answer.
I'm saying that I cannot answer for the petitioner. You're asking me questions that ought to be asked to the petitioner. Right. And I'm saying that I'm not.
So, are we going to that?
I took these figures from the respondent's declaration.
Now,
and before they were declared, I couldn't have known what he was declaring.
The figure at the time.
Now, can you read paragraph 13 of your witness statement to this court?
My Lord, paragraph 13 of my witness statement. When the percentages of valid votes cast and standing to the names of each of the presidential candidates. Oh, my witness statement, okay. Witness statement. Have you taken? You've taken the witness statement.
It's over there. Let me show. Bring book.
It's here. 13. Yeah, paragraph 13. The Techima and South constituency has a total registered voter population of 128,018. And if added to the total valid votes announced by Mrs. Jane Adukwe Mensah as cast, which is 13,434,574, the resultant figure would now be 13,562,592. Consequently, if all the votes of Techima South constituency were added to petitioner's votes, second respondent's vote will remain the same at 6,730,413, now yielding 49.625%, while the votes of petitioner will increase to 6,342,907, now yielding 46.768%.
So I'm putting it to you that you knew the results from the Techima South, and therefore this analysis of yours is incorrect.
My Lord, I beg your permission to quote paragraph 12 of my statement. That will explain the meaning.
Please answer the question and then you can explain.
Okay.
Answer the question. I'm saying that at the time you were making this statement,
yeah,
you knew the exact results of the Techima South constituency, and therefore the analysis that you had made was wrongful. Answer the question, yes or no. If you want to explain, you explain.
The analysis was right because it was based on a statement made by the first respondent at a certain point in time. So if you are analyzing that statement at that point, I don't see how you bring in the current situation to be able to answer that statement.
I suggest to you that you are wrong because the current situation is the reality. The court deals with reality, not conjecture. I'm suggesting that to you.
My Lord, the current situation cannot be the reality because nobody knows the results of the presidential elections in 2020. Nobody knows in exactitude how many votes each of the candidates got and what percentage each of the candidates got. And the first petitioner, the first respondent, in her own words, and my Lord, I beg to quote in my own statement, currently, the election results we have declared exclude that of Techima South constituency, with a voter population of 128,018. The third election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it would not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techima. The respondent was justifying why she had to declare results based on uncompleted tally. And you are questioning that statement, that statement could not have been correct as at the time it was being made.
I am putting it to you that as at the time the first respondent's chairperson made that statement, the statement was correct and it is captured in paragraph 12 of the petitioner's petition.
I decline that.
Very well. Now, what was the source from which you obtained information to draw up your Exhibit E for this honorable court?
My Lord, Exhibit E was based on the first respondent's own data.
But you have gracefully brought it to the attention of the court. You want to rely on it. Is that not so?
Yes, we want to rely on it to the extent that we want to prove a case against the first respondent.
No.
And I'm comfortable, I'm a teacher, my Lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of Exhibit
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From where, please?
That's the total.
Yeah, the
total valid votes.
Yeah.
Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes.
Yes.
And then also for the petitioner, we have 6,265,276. Is that correct?
According to these documents submitted by the first respondent.
No. It is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way you have rendered it, that's why.
0.51.
Yes. 0.51261471. Is that correct?
That's correct.
Now, I am suggesting to you that this works to a percentage of 51.2614.
Percentage of what?
A percentage of the total valid votes also on this sheet.
It's 51.263%.
That is correct.
Yeah.
Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct?
47.397. Yes.
Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned from assigned to the petitioner from that assigned to the second respondent and tell this court the difference.
Which of the numbers? You asked about percentage.
6.
You are now asking.
6, 7. Yes, I've moved on from percentage. 6776066 minus 6265276. What do you get?
677.
As it's not that good, I think you'll be stretching the witness.
About 510,790.
Thank you. Thank you very much.
It's okay.
Yes. It is, you got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded any votes as you allege. I am putting it to you.
My lord, I decline that assertion.
Now, in your Exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is your allegation.
My lord, if you look at my statement, I indicated that I'll bring a sample of the constituencies and polling stations where padding took place. I did not indicate that that is an exhaustive list of all the places where the padding took place.
Sir,
and if we ever want,
we are using the numbers that you have brought to the court to assist the court. I am saying that the total of 4693 is what you have put down there. Is that correct?
I brought it as a sample. I did it in my statement, actually indicates that this is from a sample of this particular constituency. I don't understand sample to mean a total of the population.
Now, deduct the 510,790, you deduct the deduct the 4693 from 510,790. What do you get?
With all due respect, I don't see the point of the
with the greatest respect, you are being rude to the court, not to me.
Okay. Yeah, come again.
I'm saying that deduct 4693 from 510,790. What do you get?
693. I got 506097.
Good. I am suggesting to you that even if this your number as alleged, which is denied, even if it is deducted from the total valid votes of the second respondent, he still has won by your own sheet by 51.246%. I am putting it to you.
My lord, I deny that because that you are subtracting apples from mangoes.
1 point.
But this is a sample. You want to take a sample from a population of another group. I don't see where the calculation is coming from.
You see, I am suggesting to you that you have no evidence to support your allegation, and that is why you have brought only what you have. I am putting it to you.
My lord, we are not in court to try to declare another presidential results by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged faithfully.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I decline that, my lord.
Now, you had earlier told this court that you cannot speak to what happened in the strong room when your two representatives were there.
Yeah.
Is that correct?
That's correct.
My lords, on that basis, I'll end my cross-examination of the witness.
Yes, my lord, I do. So, Mr. Seydou Nketia, you recall that before the declaration of 7th of 9th January 2021,
December.
9th December 2021.
Mr. Kutampa.
Oh, relax. 9th December 2020. Your party and your presidential candidate held a series of press conferences on what you consider to be the outcome of the elections. Is that not so?
It is so, my lord.
And in those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was, by the votes you had collated, the president-elect. Am I correct?
My lord, that is not in my witness statement.
No. Where is it? Yes, the paper. So can you answer that question? You did say so, didn't you?
Come again.
I said your party, including your good self and the first petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press. So I'm putting it to you that your party held a number of press conferences.
Yes, my lord, that is so.
Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections.
Yes, my lord.
The petitioner himself also spoke on the outcome of the presidential elections.
Yes, my lord.
And your as deputy, Tokuno, equally spoke on the results of the presidential elections.
My lord, I can attest to my statement at a forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke.
Now, you know that your presidential candidate, that is a petitioner, asserted.
Unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that will give President Mahama a comfortable situation to be able to run the next government.
So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president.
My Lord, there were all indications that he was going to become the president.
Not indications. I'm saying that by what you said, you meant that he had won the elections because that was the only way he could form the next government.
My Lord, if I meant that, I would have said so.
See, Mr. Asedin Petia, we served on the petitioner our witness statement.
Yeah.
You are aware?
My Lord, I'm not the petitioner.
I didn't say you are the petitioner. I said we served on the petitioner our witness statement.
Yes, I'm aware he has been served.
Have you seen a copy of the witness statement?
Yes, I've seen it.
Do you admit that in the witness statement of the petitioner, of the second respondent,
yeah,
we have attached Exhibit 6?
Exhibit
6.
This one. Yeah. This is it.
Yes, can you answer?
Yes, I've seen this in a brown envelope.
Yeah. So we presume that you know the contents.
I didn't hear.
So we presume that you are speaking, you know the contents of that video clip.
Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained in there.
My Lord, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at that moment giving testimony. The witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. In our witness statement, to discredit him. What he's saying. Now, at the time that he would have finished his evidence and stepped out, when we leave that evidence, he will not be available to respond to the content of that evidence. We want to play the video so that we will exactly. Yes, my Lord. Very well. Yes.
Mr. Kutuampa.
Yes, my Lord.
You are conducting your case. So if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. But as it is, you've not made any application. We have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
My Lord, may I, with your leave, make an oral application to have the video that we've attached to our witness statement played out, so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, on the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video,
my Lord,
establish?
The relevance is that the petitioner and his supporters or his leadership led Ghanaians to believe that they have won the election, and that there was an attempt by the first respondent, together with, in collusion with the will of the people, and that they had all the necessary pink sheets to demonstrate that they had won the elections. When they came to court finally, after a lot of pressure from the public that if you won't come to court, all they are saying is that if you use the errors in the chairperson of the first respondent's announcement, then neither party has won. So there should be, through their good faith and credibility.
But
in this matter.
Mr. Kutuampa, anybody at all can call a press conference and declare himself or herself to be the winner of an election. And you mean because I called a press conference and declared that I have won an election, that should be taken as the law?
No.
We have laws, we have regulations,
no.
And how we know how to declare our results.
My lords, where a major party in the republic, like the NDC, is mobilizing its...
Mr. Kutuampa, you see, the witness is denying these allegations. Yes, that is why you have your witness statement together with this, would I say, proposed exhibit or whatever, served on him. If it is your time, or if your time comes, then you have to put in.
No, yes, my Lord, what I'm seeking to, I'm actually applying to the court for leave to play the video and use it because it's part of our case, and use it to cross-examine the witness. And my Lord, I'm saying that this is a difficulty.
You are talking about credibility. You want to establish credibility.
Yes.
Yes. So you haven't said so.
No, my Lord, I said it goes to his credibility. I said so.
You have to premise your application in the rules, and you have to premise your application in the rules of court and in the Evidence Act. That's your job. That's your burden.
My Lords, I mean, our application is relevant to this petition to the extent that it demonstrates the credibility of the petitioner in respect the credibility or lack thereof of the petitioner in respect of the 2020 presidential elections. And yes.
So what is your submission? What is your submission? What is the application that you want us to?
My application is for leave for the video.
Confront him with the exhibit.
Yes.
Okay.
Because he's been very evasive, almost to the point of denial.
The challenge we have is that you did not give any indication prior to this hearing that you want a video to be played.
My Lords, it's attached to our witness statement that I believe all your lordships have copies of, and I have every reason to presume that you know that we like to play it.
I'm not sure whether the registry, Mr. Registrar, I'm not sure whether there is any provision made for that. Do you have? Yeah.
I always take an adjournment.
My Lord, I respectfully, I believe that we have not been heard. There have been several steps of questions and so on. We have not been heard even in respect of his basic attempt. Okay.
Submission, the application. He said he was making an oral application.
Right.
Yes.
Yes, that's why I was saying that my understanding was that the question from His Lordship Justice Amegache was about the practicality of implementing that.
Yeah, it has not been granted. So we have to hear you before we can rule on it.
Very well.
Yeah, okay.
My Lord, in the first instance, it is a case of the petitioner that is being made by this witness. And therefore, evidence that he says is part of their case, that evidence has not yet come in. And your Lordship will see that, in fact, literally, whilst in the box, he opened that envelope. I mean, it was clipped. I think we all saw that. It was clipped, and he answered that, I mean, he has not seen that tape. So So, my lords, in terms of the answers that he's given when the matters have been put to him, he has answered those matters. Now, the question now it is now being proposed that even before they bring in their witness statement with this flash drive, it should be put to him. That witness statement is not yet in evidence. It's not been adopted in evidence. So my Lord, with respect, the procedures are simply being confused.
From this witness statement, which is, would I say, an invention into our rules. Well, you see, in some years back, before the coming into force of the, is it CI 87? CI 87. Yes, you can just ask a witness under cross-examination that, please look at this exhibit. Did you append your signature to it or whatever? That was the practice. But yes, then you may even tender it through the witness under cross-examination, which was permissible. But of late, because of the CI 87, it is.
You remember, if you are conducting cross-examination, if you remember, you can pull out a document.
Yes.
And show it to the
the witness. Yes.
Yeah. Lord, that document may not be in evidence.
My Lord, I have absolutely no problem.
So it's the same principle.
No, my Lord, with the greatest respect, what he was showing the witness was an attachment to a witness statement that has not yet been adopted. That's very different from the...
So it is not evidence yet. It's not evidence yet.
No, my Lord, with the greatest respect, I'm saying that your Lordship has described a scenario which is clear in terms of the procedure other than the procedure that is being used now. In that procedure, that evidence would not be part of a witness statement or anything like that.
Yeah.
It would be a document that in itself can be tendered through the witness. And I don't have a problem with that. I'm just saying, my Lord, and I think with the greatest respect, this is also an indication of a problem arising from the fact that the case management process was truncated, with the greatest respect. Because, my lords, in the case management process, you would normally be able to indicate these materials which you would want to put to the witness. Then, in the case management process, your lordships would have the opportunity to make this practical arrangement that was being described by His Lordship Justice Amagenshi, whereby if that is a document or that is a video that they want to show and so on, that as a piece of evidence to confront him would be catered for. So, my lords, I'm respectfully making two very simple points. Firstly, in terms of the procedure that he's seeking to adopt, bringing in a witness statement and an attachment to the witness statement, that is irregular. Secondly, because that witness statement has not been adopted. So
it's not evidence yet.
Yes.
That is why they can do what they are doing. Because it's not evidence until they come to the box and adapt it. It is no evidence. So it's like they are having a document. They want to confront the witness with the document. That document is not in evidence yet.
That is why
so we are speaking the same. We are on the same level. We are on the same wavelength. What they have now, even though it has been filed, is not evidence. So they have it.
Yes, but my lords, you heard him. The application that he made is that it is part of our case that so and so.
Yes.
He said that.
Yes. So it's just electronic evidence. If it were any ordinary document, he could just give it to the court clerk to show it to Mr.
Yes, my lord, as you said, we're on the same wavelength in terms of the practice related to showing a document, a video, or whatever. We are absolutely on the same level. I'm just referring to the way in which he sought to bring it in through referring to the witness statement, which is not yet in, to a witness who is under cross-examination as the petitioner's witness. That's all. But, my lord, clearly, documents can be put to the witness under cross-examination. I don't have a difficulty about that. That's why I was saying that the practical problem that we're in right now is because if in case management it had been understood, and I believe that was the question that His Lordship Justice Amagenshi was asking, if it had been understood that that document would be required for the cross-examination, then arrangements would have been made practically for that, because it happens to require some technology for it to be shown. So that is what I'm saying. And so we are in a situation where, the practicalities do not allow for the procedure that your Lordship is referring me to, which I agree is a procedure that can happen under cross-examination. But because of the way that it was sort of introduced, we've ended up in this situation. So if we can, I suppose, go back to some case management and so on. And I mean,
so all we need to do is to secure the equipment that can be used to play to the video to the witness. That is.
My lords, it was precisely because of this that when I got up, I sought to have directions of the court because of the new novel processes of witness statements and what it means for putting your case to.
Even if we were not in an era of case management prior, where you bring you show all your evidence, you still would have access to this through the Evidence Act. It's just about electronic evidence as compared to paper evidence. And so the system has to be set up if you apply fully.
We have actually notified the registry that we would be needing very well. Very well. My lords, but that is why I made our application. Oh.
My lords, whilst you're considering these practicalities, I would like to indicate that we would, by the same token, especially once the technology is available, we would wish to have the declaration made on which he has testified and which is part of our witness deed, the declaration made by the chairperson of the first respondent to be played also. We have the exhibit, so we would also, just for the sake of completeness, because whilst we're discussing all this technology, I think very well. Exactly, that's all I'm saying.
By court, counsel for the second respondent wants the court to have access to the content of a prospective exhibit which has been annexed to the witness statement. As this attachment is not in evidence now, we hereby order that it should be placed on the next agenda date for us to ascertain its admissibility on the grounds of relevancy. Yes. Yeah. Yeah. My court, the petition is adjourned to Monday, the 1st of February 2021 at 9:30 a.m. for continuation of cross-examination.
You have to start.
Yeah. Please, you've not been discharged. Yes. So Monday, they may continue to conduct the co-examination.
Very well, man.
Yeah, I will tell you.
We are ready to collaborate with the registry to provide the necessary facilities, if need be. Very well.
Thank you for your unsolicited assistance. Danny?
All rise.
Diary brought to you by the Communications Directorate at the Presidency.
Watch The Presidential Diary this and every Sunday at 6 p.m. and repeats on Tuesdays at 2 p.m. only on Net2 TV.
Net2 Television, beyond the limit.
Economy, politics, sanitation, agriculture, education, join me Monday to Friday as we dialogue on issue-based politics, live on the Dialogue Show.
Watch the Dialogue Show from Monday to Friday at 7:30 a.m. to 9:20 a.m. only on Net2 TV.
Learning to read, reading to learn, learning to read, reading to learn. Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream and it's to be a better person. I have a dream and it's to help my nation. Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn. Susu. Susu. This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Net2 TV.
Many years of undercover investigations, I bring you the secret issues that borders many Ghanaians here and around the world. The politics.
I am fully committed to being fair and impartial.
The current affairs.
The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us.
Investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Zongo community not to have education.
The show is The Secret. With me, Kweku Anand, your host, only on Net2 Television.
Make a date with Kweku Anand on the seat of accountability, performance, and justice on Net2 TV. Log on to www.net2tvgh.com for your local news, news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2 TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limit.
Hello everybody, welcome again to another episode of Chinese for Business People. Your host is Nana Kwame Jemfi. In the previous episode, we learned the word Jiang Chue, which means right or correct. Bu Tuo, which means right or correct, also the same thing. Jueda, which means think or feel. Now Jiang Chue and Bu Tuo are used to replace Dui, which also means the same thing. So Jueda, we use it in the sentence, I think Chinese is not difficult. Well, Jueda, Zhongwen, Bu, Nan. We learned that the Chinese language is Zhongwen and the country China is Zhongguo. The next word was Ye, which means also. also, which was used in the sentence I think so too. Wo ye joda. Wo joda John Wen Bunan. I think Chinese is not difficult. I think so too. Wo ye joda. Now, in disagreeing to this sentence, I don't think so. Wo bu joda. Instead of I think Chinese is not difficult, we rather say I don't think Chinese is difficult. Wo bu joda John Wen hen nan. I don't think Chinese is difficult. Wo bu joda John Wen hen nan. So joda again is used when you want to express how you feel, what you think, or your peace of mind about something. So let's move on to the word also, yeah, which was used in the previous sentence, I think so too. Woye joda. Our sentence is, if you are not going, I'm also not going. If you are not going, I'm also not going. Ni buchu, woye buchu. Ni buchu, woye buchu. It's very simple. Ni is you, buchu not going. Wo is I. Yeah also, buchu not going. So literally it's you not going, I also not going. If you are not going, I'm also not going. Ni buchu woye buchu. Another sentence with the word yeah. He is a teacher and also a businessman. Teacher is Lao Shi and businessman is Shang Ren. Shang Ren. So the sentence, Ta shi Lao Shi, Ye shi Shang Ren. Ta shi Lao Shi, Ye shi Shang Ren. Ye shi in the sentence means also is. Also is. When you say wo ye shi, it means I also am. Wo ye shi, I also am. I also am is literal, but it is me too. Wo ye shi. Now let's use wo ye shi in a sentence. Me too. I'm sure we all know how it's used in English. It's the same thing. For example, when someone says, I like to travel, and you also do like to travel, what would you say? Me too. So let's translate this. I like to travel. 我喜欢旅行. Me too. 我也是. 我也是. Or you could say I also like to travel. 我也喜欢旅行. 我也喜欢旅行. Using the word 也 also. I also like to travel. Now with the word me too, we are forming another sentence. Chinese food is my favorite. Chinese food is my favorite. 中国菜是我最爱的. 中国菜是我最爱的. Me too. 我也是. Me too. 我也是. Now in the sentence, 中国菜是我最爱的. Favorite is 最爱. 最爱. Literally, this word 最爱 means most loved. 最 is most and I is loved, so most loved. What you love the most is obviously your favorite. So we've come to the end of this episode. Take note of the word businessman, Shang Ren. Teacher, Lao Shi. I think so too, 我也觉得. You can review this on our YouTube channel at Net2TVGH or on our website at net2tvgh.com. This is Chinese for Business People. My name is Nana Kwame Jenfi. Have a wonderful day. Stay safe and keep
of the press, and by extension the entire Ghanaian public. After a long day in court, the justices of the Supreme Court have had to adjourn the proceedings of today to Monday, the 1st of February 2021, to enable second respondents team play a video which was annexed to the witness statement. You all saw the proceedings in court through the morning to this late afternoon. We started by the second respondent objecting to offending paragraphs in the witness statement of Johnson Asiedu Nketia, the General Secretary of the National Democratic Congress, on whose ticket the petitioner John Dramani Mahama stood as his presidential candidate to contest the December 7, 2020 elections. Out of 10 offending paragraphs, the court graciously admitted 3 of the paragraphs to remain, and 7 of the offending paragraphs were removed in part, but 1 of them was totally expunged from the witness statement. It is pertinent to state that 1 of the offending paragraphs related to the pedestrian allegation of Asiedu Nketia in his witness statement that the chairperson of the Electoral Commission has a familial relationship with Her Excellency the First Lady of the Republic, Mrs. Rebecca Akufo-Addo. We all witness the strenuous and tedious submissions by petitioners' lead counsel to answer to the objections which had been raised to portions of the witness statement. It was a repetition after repetition, which prompted lead counsel for second respondent, who could not bear it any longer, to remind the court of the petitions, of the repetitions. When Mr. Johnson Asiedu Nketia took to the witness box, he remained largely evasive. Every question that was posed, his immediate response is that I do not speak for the petitioner. This is someone who in paragraph 2 of his witness statement has stated clearly that he was in court to end or lend aid to the petition filed by petitioner. How can you come to court as a witness for a party, and when you are asked questions in court, your response is that I don't speak for the petitioner? Then why are you in that court? Why are you then in the court? He thinks he can be as elusive and invasive as he was in 2013. This time around, he will not be lucky. Now, it is very instructive to let all Ghanaians know that the one person who filed the petition, which is John Dramani Mahama, has refused, failed, or neglected to sign onto a witness statement. As we address you this afternoon, the petitioner himself has no witness statement before the court. This is a petitioner who seeks to have the elections annulled and is praying for a rerun. This same person is refusing to come and give evidence in court. The judgment is with the Ghanaian public, not mine. When Johnson Asiedu Nketia went all about town, he said one thing which is poignant. When he was posed a question by a lawyer for first respondent, his response was that we are in court to challenge the conduct and constitutional duty of first respondent. We are not in court to challenge the elections. I mean, that is Johnson Asiedun Ketia's own statement, not mine. We are in court to challenge the conduct and constitutional duty of first respondent, not the elections. So this is where we are. As I always do, I will allow you to ask questions, if any.
First question.
At the latter part of proceedings, you made a request, wanted to confront the witness with a certain video. I mean, we're just wondering how exactly does that help your side of the story? Because the contention that they have put in their petition in terms of what they have filed is to make the case that...
Can you repeat your question again?
Yeah, I'm saying that at the latter part of proceedings, your side put in a request for a certain video to be allowed so that you confront the witness with it. I'm only asking you to explain to us how relevant it is to the case, in that the substantive matter that is before the court is the claim that no one had more than 50% of the votes cast, not the claim that no one won, like that someone won by more than 50%.
In court, the test for every witness in court is the witness's credibility. So you realize that when we went on and on and on, the final leg of the submission was that we want to attack the credibility of the witness. And it was at that point that the court was minded to grant the application for a play of that video. Now, the relevance, to you it might not be relevant, but the relevance is that these are persons who, after or during the course of the elections, had proclaimed to Ghanaians. In fact, the presidential candidate himself, John Dramani Mahama, the General Secretary, Johnson Asiedun Ketia, the Deputy General Secretary, Otokuno, the Director of Elections, Evisafi Ankra, and their communication officer, Sami Jemfi, had proclaimed to the whole of Ghana and the world that their presidential candidate had won the presidential elections, and they had secured, some were saying 140 seats in parliament, others were saying 141, others were mentioned that they were not even sure. And when they proclaimed that they had won the presidential elections, they gave you percentages. Don't pretend as if you didn't hear. They gave percentages. And some of them were calling the presidential candidate president-elect. I think I recall, Sami Jemfi, a communication officer, referred to Mahama as the president-elect. Some of them even urged him to form a parallel government. Now when they are being invited to the police, there's another story. They advised him to run a parallel government because they had won the elections. Now these are the same self-people who now, when come to court, cannot even tell how many votes they garnered and are asking for a rerun. Does that sit well with you? And you think it sits well with Ghanaians? No. But you see, I must point out also that the exhibit that Asiedun Ketia was confronted with was their own exhibit. The exhibit E. It was their own exhibit. In his testimony, they failed to sign on to regions where it was abundantly clear that the petitioner had won elections there. Their agents in the strong room decided to take a long jump when they realized that the results proved unfavorable in their cause. That is my answer.
All right. My question is in reference to the claim
the remark that you said Mr. Johnson Ketia made in court. Indeed, what we heard him say was that he is not the petitioner and not that he does not speak for the petitioner. You are lawyers. When somebody says, I am not this person, it's different from saying, I do not speak for that person.
Have you read paragraph 2 of his witness statement? Maybe if you read paragraph 2 closely, on Monday when I come, we can have that engagement. But when somebody says that the petitioner stood on the ticket of the National Democratic Congress to contest the elections, and I, the General Secretary, the Chief Executive Officer of the party, I am swearing to a witness statement to give evidence in support of the petition filed by the petitioner. Would you still want to maintain your question?
Well, I just want a difference, to know the difference between when someone says, I am not the petitioner and I do not speak for the petitioner.
A witness only corroborates the case of the party. You don't become a witness in court because you have sprung up from somewhere, maybe from Mountain Kilimanjaro. You become a witness because there is a leadership party in the case. John Dramani Mahama has not donated a power of attorney to anyone to speak on his behalf. It is Johnson Asedun Ketia and Dr. Kwesa White who are coming to speak as witnesses. And they all state that they are speaking in support of the petition. So you cannot come to court and lend aid to a petition, and when you are asked questions in court, you say, I am not a petitioner. So what are you? Are they aware someone?
Okay, that's it. Thank you very much. Thank you.
I would end, as I always do, if you have nothing to say about another person, whether that thing is useful or beneficial, then please do not say anything at all. Because if you invariably say what you want to say, you will prompt the other person to also say something or respond in a way or manner that may or may not just otherwise be pleasant to you. Let's all be guided by fidelity to the truth and don't bear false testimony. Thank you.
Major Chief for lawyer upon now on Casas here. Lawyer.
You remember the tougher near Ohoni say Emre Saudi Asemuba Kota. Ese ensem no ni nyina pese court no egitumu no odi ni nyina beto court no maybe sade ayechi ni se odi asembe ba na chire no obesisa wano obroni se obe surprise other party no enti yempenisa eni ti obehwe a owura Mahama de asem ni ba court no ensem bi wo ho a okan nenso owura se Ketia de ni witness statement ni ba no ensem ni bi wo na Mr. Mahama na ankasa ye ni case no wan fan shim Nekobasa na enyeso wa surprise yen ye won chen no nko ani mom ukura mpo ye ma osi ya me ye twam sisi efi se ade emrachi eni so obi di na asema ba na ni witness eni na ji hu achinyi efi se ni witness ne ka no soronko efinia nipa na so odi asem no ba ye no e kan ti twakura etwam sisi ne ye efi se enke ewie case ni e tra addresses a enke bi ensem e be ka wo mra kwan so no e ma asem no kure betwam ntem enti mi gise ese omoda yase yaboa omsabre na ne ho biem ni se senia ensem ni course ne no ubehu se ensembusa no eba no de se bi munyina mo court ho muhu senia no ye ne ko ye wie enti mi nkan kosi ase bebre nanso ba bia ye du ni se ensembusa ne ba ye se eyembra ye to aba ni wie ye no penifo bi e wo NDC mu na Mr. Mahama Nkasa former president omo kan se abane de owura Mahama na ewi ni
one touch
mi kuma me chia ne sisi asemi jamfi nso kan bi se president elect na akono ye nanso na nipa bebre ehwe ni mu senka owura Mahama de case ba Supreme Court no obeka say yen twa abatuo num owura Kufuado wanwini na mum owura no Mahama no na wini na nka yen ka say Supreme Court enkansi so senior 2013 na Kufuado ba court no enso ekoye nwanwa say omo ba court no owura Mahama say wanwini na mum owura Kufuado nzo wanwini enti no eba ni saade a yenkoto aba ne mo mienu nya na gum nya kuadon komu nya yenfo mu sinchen enti eho ne ejina sese enti o de tronsem a sebi ono ani na pamfo ekan ya e ma supporters bebrani giye eni be bia nka esese otimi kansi so sampa mi wini ene bia ya wia me no antimi ameka sempo ya wia no na wanso antimi ameka se me na mi wini ye ne ya bu me bukata no eno ne ma krofo bebre adwemu ye om na kakra nti e bia adwada ye bo video no ana tape na munyam be hwe bi atie bi na se bi munyam ye badwema na motimi di mani ni maso nyina abu ba bi ejina no no tie dama se
Good afternoon, ladies and gentlemen of the press. I want to start by letting you know that today was very eventful. And I'm sure when you watched the proceedings, you came up with the impression that the John Mahama team brought a solid case to the Supreme Court. In fact, when we filed the petition, it was being bandied about all over the place that our petition was empty, that it had not disclosed a reasonable course of action. Well, today was your answer. I am sure you saw vividly the evidence that was being led by the General Secretary. We have not yet concluded the hearing, and so I will not comment on the merits of what he said. But I'm sure you are all witnesses and you know that this is not an empty case. Now, let me correct one misrepresentation, very deliberate and gross misrepresentation that lawyer Frank Davis, my very good friend, has made this afternoon. He sought to give the impression that we came to court because we wanted a relief to the effect that His Excellency John Dramani Mahama be declared the winner of the election. I am sure, as ladies and gentlemen of the press, you have read our petition. Nowhere have we sought that relief from the court. What we have sought from the court is very simple and may be summarized in two. First, we want the unconstitutional conduct of Jean Mensah to be held to account. Secondly, we want the court to declare that none of the candidates met the threshold requirements of Article 63, Clause 3 of the Constitution. That is the crux of our case. And that is the case that we have sought to make in court today with the witness statement of the General Secretary of our party. Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013, His Excellency Nana Addo Dankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Addo Dankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change and compel him to testify? I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls. Also, it played out in court today that if we had done proper case management, as we were pushing, we would not be where we were this afternoon. You remember we complained bitterly that case management, as stated in CR 99, was supposed to last 5 days. The court compressed it to 2 days. And in fact told us that we had spent the first day of those 5 days making the case for the interrogatories. Now, it played out in court today. The importance of case management. When they sought to tender the pen drive that contained the so-called videos in which principal officers of the NDC and our presidential candidate made certain statements, you saw what happened. The court was not prepared to play that video because it had not anticipated that it will be needed, and there was no equipment in court for that purpose. As practitioners, we know that at case management, that issue would have come up, and the court would have been prepared that on day 1 of the trial, a video will be played showing evidence of statements that our principal officers made. Ladies and gentlemen, it is very important for us as a party to underscore the fact that we are not in this case because we want to joke with the Ghanaian people. At the end of the day, the issues of accountability, the issues of the mathematics of Article 63(3), and you very well, you saw it in court. When calculators were flying around, were we the ones who brought the calculators to court? Were we the ones who brought the calculators to court? But we warned you that this case, a big plank of the case, concerns the mathematics of Article 63(4), whether or not Nana Addo Dankwa Akufo-Addo, as a presidential candidate, crossed the constitutional threshold of more than 50% of the vote. Our case is that he did not. And we will prove that in court. Just watch out in the next few days. Any questions?
Any impact on the case as you have put together?
No, we don't think it has any impact on the case we have put together. We are allowed to bring those matters back, when cross-examining their witnesses. So we don't think that it in any way, destroys our case or minimizes the probative value of whatever evidence we are bringing. But note that they raise the objections based upon the so-called scandalous nature of some of the averments or some of the statements in the witness statement. All right? Now, we had alleged that she acted in a biased manner, in an arbitrary manner, in a capricious manner, that was motivated by personal dislike for His Excellency John Dramani Mahama. If you put it in the converse, her likeness for Nana Addo Dankwa Akufo-Addo, her preference for Nana Akufo-Addo. And that is how come that in our witness statement, we sought to make it abundantly clear that she had a familial connection to the Akufo-Addo family, that she's a relative of Her Excellency Rebecca Akufo-Addo. Now, if that is not material, what is? If you are a family, a relative of the First Lady, are you telling us that you don't want her to continue to be First Lady? So we said that she did it, with a predetermined agenda designed to continue, to let her sister or cousin continue to be the First Lady by announcing that Nana Addo Dankwa Akufo-Addo was the president.
So you have made it clear to us that the petitioner himself will not be in the box and that he has assigned witnesses to make his case for him. However, in court, at least more than 5 occasions, the petitioner's witness declared that he was not the petitioner and therefore did not answer certain questions that were thrown at him.
Well, that's an excellent question. It means that you were watching the proceedings. let me make it clear that in those instances where the witness said that he was not a petitioner, they wanted the witness to give evidence with respect to the state of mind of the petitioner. Okay? Anything attributable to knowledge that is within the personal, knowledge of the petitioner. I mean, how do you expect a witness to be able to testify to those matters? And that is how come that he legitimately declined to do so. It is not because he is distancing himself from the petitioner. In fact, he is not here under compulsion. He voluntarily agreed as our general secretary to testify because he is the chief administrator of the party. He coordinated with the help of the chairman and the other principal officer. He coordinated the election. So who better to testify on our behalf than our general secretary? And that is precisely what he was doing. But if you insisted that he should speak the mind of the petitioner, he should testify to matters within the knowledge of the petitioner, he would decline. And that was just as it should be. And in law, the general secretary was right in declining those questions. Any other questions? All right. Thank you very much, ladies and gentlemen of the press.
Okay. Let me just do that. Doc, let me do that. Abusianfo, your best friend, Yatre, and then the course of the Supreme Court of Ghana, Ewuchi Kasem. Na Sakra na Metre, the Dr. Ayine, Akano Potokasem, Wuchi Kasem. Frank Davis, Oye Kasamafo, Emma, the second respondent, Eya Nanado Danko Kufuado. I can send Bia, I was a year no na Ghana for Anye Sibio sa in Kuntumpu Semino Antum. Yedikai Samutian year, or you see where to be say about 10 passages never General Mosquito witness statement Muno Omokasa court no mungu. Na court no bomun sungu ye because San Semino a pedestrian, Chese Sibio a Yakushisem. Busanfo Munina Moshe, the course or court in be with TV so. Court no bought sa in Semfuan no guno. Court nanka beviase a pedestrian. Court nanka say Yakushisem. Person ka court no be boss San Semino good because a Yakushisem a scandalous. Be court nanti. The court no kaya and say wa boss San Semson agu. Because say any your petition, the dear friend of pleadings, it has no foundation in the pleadings. That is different from Saubeka say, and someone a war General Mosquito a dance crater muno, a pedestrian. Now ye pay attention and you raise this issue because of Bibi Kwakoye Yenuano Mokasama second respondent Suban said. Maybe I be free court abahabiano or be use casetrie and say bin somewhere any say free a lawyer for ano a day akasa for the course of court. The last time it was intransigent and right it was somebody who had a jaundiced mind and there will be a passages here pedestrian. You best need him say a lawyer for we are this year money at 30 or quite I was here for Sokasa. And when it is free court, now what about can someone across a court? The court won't can and can't court nano. If the courts in dismissing or upholding those 7 objections, did not say a pedestrian, that conduct is unbecoming of a lawyer of the standing of Frank Davis. The best stress, you never condemn, and a bear encoso because a bit to me. Aha, asemwa court no edi. The atosubiem okase omampenyi John Dramani Mahama ode na asema ba court o ye petitioner no. Onfa dance krata bia maye. Enu nti no eno kire se oni asem bia. They said the doctor yi ne chechire mu opoto kasam no. Sa asem ne so eye mfuturu a ye nuanom etugu Ghana fo ani. Because wo mramu no sa wo de wasem beto court anim se court nka wasem as petitioner. Bibia ni we sha wo se e wo se wa obedi adanse ma ho emrane ma ho kwan se utimi fra adansefo ma adansefo e bedi adanse ma ho enu nti na in 2013 election petition no o mampenya kufu adode na asem bae as the petitioner no ono wa medi adanse ni bi wama obi aso mmara krata the friend of power of attorney say omegina nenamu eya dansefo Dr. Bawumiamo eno from mo wo bedi adanse ma no enti de yewura jo mahama aye no edimu ewo mramu a bibiboni bi anim ti nsem a ye nuanom kan ne no so no eni nyina so bia wo mram ti e be stress eno so ye de beto nchen ebiem oka se NDC for emra ye to aba ne wie on 7 December ye ka kira wiase nyina se ye coalition ye nkonta ye bu kire se ya win election no but ye ba court no ye ka asem foforo se court no order for runoff na no kire se ye witness asiedu nketia na NDC for ye nya no kwafo obobo ye nyina ye di ne de keka ho abusianfo sa semi a ye nuanom MPP fo aka ne he ya o maka ne baby bebre no de kire ne pa ne se ya semu a ye de aba court no omonti ase yenti a ye kasa ne se ya semu a ye de aba court no has got nothing to do with the coalition ayaye any ye figures ayewo wo mramu no se obi tia wo na so mprem nu now the lawyer for friend 2 courses of action against the person una obe choose the wo de baba court kane nti ampa ya press conference based on pink sheets ne results ayewo ye coalition yaka say John Dramani Muhammad nkunim but assemble ya the aba court that is not the nature of it. Assemble ya the aba court no has to do with the constitutionality of the declaration ya jimensa aye. Yes, the constitution they say who declare obi say wa weni o mampanyi abato a e was say nipa kro no wanya emapano mu ohamu chichemu adonum ne akire pe ensam ni figures e wa declaration mu no mampanyi kufu ado anya nti we declaration ni tiaga na mra kunyini 1992 constitution na just mramu no declaration no doesn't even exist. So if the declaration doesn't even exist there, then issues about the coalition yen yedim kunim no in the view of our lawyers no emamu ansa. So we have elected to challenge the constitutionality of the declaration of Jimensa. That is what is in court. At the appropriate time, say was said ye kasa about the coalition ya ye ni adanse ye chese ye ni arena ye beka mwasem. But let in some way ye can about the course of court no ye man in fact in some way that court nanim which is about Jimensa adwuma waye about wa wabobo any whether or not to say edimu results are declare no edimu ewo emrem abusianfo ebiem omaka say oh Yewura Johnson say dun keti adanse mu no oka say he is not John Mahama the petitioner enti no kire say Yewura say dun keti anim de oka na petitioner ni nim asem o de ya ne say a lawyer fo a omunim de pa o mote sansem we yase no e maybe e be free court abia no maba no mutum futu Ghana fo ani utie de Frank Davis ankasa kan ya o say paragraph 2 of Yewura Asedun Ketia dance krata na wo say he is giving evidence in support of the petitioner. In support of the petitioner doesn't mean say I am giving evidence as the petitioner. Me ma dance here dia tawechi. What that means ne say as a witness evidence or the support to petitioner ni case ono ankasa nim diemu. What the lawyers will say matters within his personal knowledge. And this will be some question say now what central phone share mu bi ase anajo mama wo bia waje atum e ho no wankasa onye petitioner because I know the onim now be some question say fa petitioner no de mane kan bibi ana de na e wo ni timti a oye bibi a na je say nsem wo pese wo ka no they are not within his personal knowledge any on wankasa ni ndiem to man wa dance ye kra watomra. That should show you say and na ye penyimu pa odi adanse no oye no kwafo he is credible. Say in somewhere here within the personal knowledge in Kwano Beka Wasem. Na busianfo yeba the course wo court ni mu no. E course wo court no. E mo hwe ya nsem bisa bebre course say agents assign way o train new agents o munye o train new. They said the general secretary kan no. Ye ni nyina. But the same way the aba court no has got nothing to do with that. Obe bobo aba on 9 December. Eka kire Ghana for so mampenye Kufuado awene. We see total valid votes awugina so ka se wawene no. 13,434,574. Ye kwaye nkonta wankasa waye no o declaration ni mu a o mampenye Kufuado awene per wankasa wo figures. percentage a wodi ama no enye correct assumption a why say the Techiman South nyina ka ne ho a still candidate Mama Nsa ne ho enye correct Kwansi ma de chen ya na wasan so at the press release no kra de obi ansan sha ase aba eno so total valid votes a wo de bu nkunta ka so mampenye kufu ado awe ne yesen a they say de enye 13,434,574 biem omo say e 13,119,460 na figure na sesa eno no maka akira magana fo nyina gie di se o ma me ne yemfonso wa correct ne mfonso afeye Rajon Mahama e de asem we ba court ya se ma meji mensa be kire yen emadodo a wugina so di declare se John Mahama reni a correction na nado areni a correction a oye no 10th December eno na Ghana fo mu nyina magie di se no na ye real results no wato atwene paragraph 12 and paragraph 24 of her answer to the petition or they say the figure no enye 13,119,460 na o kan the 10th no na eye 13,121,111 that is the figures na yemiensa afa ye ko website also with the 275 constituency summary sheets agu obi abetimi akwa na wakan ne wahu abato no nsunsanso ne ye ko keka siani a total valid votes ne yesen a eno so eye 12,218,633 that is about to ba kwa yato o results nko abro nan ne akire debia esesa na eno nana Yewura Johnson Asiedu Nketia eka ho asem say that is the issue before the court and we are saying say sawutie ma me nankasa nu mu asem ni figures or the two dwa no na eno ne yese ye de be ye adwuma de a ene no mampanya Kufuado enya more than 50% of the total valid votes eno nti wani nkunim nti abusuafo de ne course so court in the court to ahye se ejoda ye beba na Yewura Johnson Asiedu Nketia waba ababetoa na dance so na yeba eno so de besi dia no ye ne mo ebedi hu komiti adam wase.
Thank you.
You are going to.
All right. Thank you very much. And that was the two press conferences held by the petitioners' side and that of the second respondents, and of course the case has been adjourned till Monday the 1st of February for cross-examination of the petitioner's witness in
Television, beyond the limits.